Roosevelt, do solemnly swear.
I, Dwight D. Eisenhower, do solemnly swear.
I, Barack Hussein Obama, do solemnly swear.
That I will faithfully execute the office of President of the United States.
The Constitution of the United States.
The Constitution.
The Constitution of the United States. So help me God.
Thank you for joining me on Contemplating the Constitution. I'm Mark David Smith. Last week we talked about Article 1, Section 9, Clause 8. No title of nobility shall be granted by the United States, and no person holding any office or profit or trust under them shall, without the consent of the Congress, except of any present emolument, office, or title of any kind, whatever, from any king, prince, or foreign state. This clause is called the Foreign Emolument Clause, Gifts Clause, Foreign Gifts Clause, and Foreign Titles Clause. This week I give you my research on Article 1, Section 10, Clause 1. And it states, no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver, coin a tender in payment of debts, pay any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. And if you're a longtime follower of the show, you'll recognize that most of what I just said, almost every one of those items in all three clauses of this section are somewhere in the past articles that we've already talked about. So as we enter into the last section of Article 1, we'll see that Section 10 makes sure that all these line items have been covered in full array. My base research comes from a couple articles found on the internet, and I'll give those to you right now. Number one is Constitution Annotated, found at constitution.congress.gov. Second one is ThoughtCo, found at thoughtco.com. And the third is the Heritage Foundation, found at heritage.org. Article 1, Section 10 limits the power of the states. States may not enter into a treaty with a foreign nation. That power is given to the president with the advice and consent of 2/3 of the Senate present. States cannot make their own money, nor can they grant any title of nobility. As is Congress, states are prohibited from passing laws that assign guilt to a specific person or group without court proceedings, bills of attainder, as was mentioned, that make something illegal, respectively, ex post facto laws, or that interfere with legal contracts. No state without approval from Congress may collect taxes on imports or exports, build an army or keep warships in times of peace, nor otherwise engage in war unless invaded or in imminent danger. Today, I'll give you my research on Clause 1, and this clause is called the Obligations of Contracts Clause. The Contract Clause provides that no state may pass a law impairing the obligation of contracts, and a law in this context may be a statute. It may be constitutional provision or municipal ordinance or administrative regulation, all having the force and operation of a statute, but are judicial decisions made within the clause. The abstract principle of the separation of powers, at least until recently, forbade the idea that the courts make law, and the word pass in the above clause seemed to confine it to a formal and acknowledgeable method of exercise of the lawmaking function. The court has frequently said that the clause does not cover judicial decisions or whatever their effect on existing contract rights. Nevertheless, there are important exceptions to this rule. In addition to granting the government powers to regulate trade and raise revenue, the framers intended the Constitution to centralize much, if not all, power over foreign affairs. Many of the federal government's enumerated powers relate to foreign affairs and have corresponding restrictions on states by using this Article 1, Section 10. Article 6 of the Articles of Confederation had permitted the states to conclude treaties with foreign governments with the consent of Congress. Treaties, as well as alliances and confederations, are formal, binding agreements between nations that are the subjects of international law. Compacts and agreements are usually made by government officials, such as executive, or by subsidiary governmental units, such as states or municipalities. In the late 18th century, governments issued letters of marque and reprisal to authorize private ships to attack certain foreign shipping and gain booty for their efforts. Issuing them was regarded as an act of war. The highest state court has final authority in determining the construction and validity of contracts under the laws of the states. Federal courts are bound by decisions of the highest state court. This rule does not hold when the contract has been impaired by state law. The highest state court has final authority in construing state statutes and determining their validity in relation to the state constitution. But this rule, too, has had to bend to the Supreme Court's interpretation of this clause, Article 1, Section 10, Clause 1, the Contract Clause. In 1922, Congress, through an amendment to the Judicial Code, extended the reviewing power of the Supreme Court to any suit involving the validity of a contract. When it's claimed that a charge in the rule of law or construction of statutes by the highest court of a state, such contract would be objectionable to the Constitution of the United States because of this clause. This appeared to be an invitation to the state court to say that the obligation of a contract can be damaged by a court decision. William Howard Taft, you might recognize that name, was the 27th President of the United States and the 10th Chief Justice of the United States, the only person to have held both offices. Chief Justice Taft, said, and I quote, "These cases were not writs of error to the Supreme Court of a state. They were appeals or writs of error to federal courts. Where recovery was sought upon municipal or county bonds or some other form of contracts, the validity of which had been sustained by decisions of the Supreme Court of a state prior to their execution and had been denied by the same court after their issue or making. In such cases, the federal courts exercising jurisdiction between citizens of different states held themselves free to decide what the state law was and to enforce it as laid down by the state Supreme Court before the contracts were made rather than in later decisions. They did not base this conclusion on Article 1, Section 10 of the federal Constitution, but on the state law as they determined it, which in diverse citizenship cases under the third article of the federal Constitution, they were empowered to do so." End quote. A contract is analyzable into two elements: the agreement, which comes from the parties, and the obligation, which comes from the law and makes the agreement binding on the parties. As far as private contracts are concerned, the term private contract is not all-inclusive. A judgment, though granted in favor of a creditor, is not a contract in the sense of the Constitution. Whether a particular agreement is a valid contract is a question for the courts and finally for the Supreme Court when the protection of the contract clause is invoked. Every case must be determined upon its own circumstances. In all cases, the question becomes one of reasonableness, and of that of the legislature is primarily the judge. While this clause may be applied to many types of common business dealings today, the framers of the Constitution intended this clause mainly to protect public contracts, providing for the payments of debts. Under the Articles of Confederation, the states were allowed to enact preferential laws forgiving the debts of particular individuals, but prohibits the states from interfering with private contracts. Today, the contract clause applies to most contracts, such as leases or vendor contracts between private citizens or business entities. In general, the states may not obstruct or alter the terms of a contract once that contract has been agreed to. However, the clause applies only to state legislatures and does not apply to court decisions. All right, next week I'll give my research on Article 2, Section 1. So we'll be going into Article 2, starting there. And Clause 1 says the executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years and together with the Vice President, chosen for the same term, be elected as follows. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or person holding an office or trust or profit under the United States shall be appointed an elector. Sounds a lot like what our Constitution in the news was about today. And pretty soon we will be going over that article, section, and clause. But for now, I'm Mark David Smith, and I just shared my research for Article 1, Section 10, Clause 1 on the Lamb Network original show, Contemplating the Constitution. Thank you very much. I'll see you next week. Have a great week. Shavua Tov.
We are richly blessed to bring you what we believe is the fullest, most diverse, yet up-to-date progressive teachings, discussion, and prayer programming you can find anywhere on this planet. Be sure to take the tour of the MessianicLambRadio.com website. I'm Susan Hoogie, thanking you for joining us on the Messianic Lamb Video Network.
Eleanor Roosevelt, do solemnly swear.
I, Dwight D. Eisenhower, do solemnly swear.
I, Barack Hussein Obama, do solemnly swear.
that I will faithfully execute the office of President of the United States.
The Constitution of the United States.
The Constitution.
The Constitution of the United States. So help me God.